You're watching Bill on Bankruptcy. I'm Lee Pacquiao. I'm joined now, as always, by Bloomberg News bankruptcy columnist Bill Rochelle. Be sure to go and read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. Bill, welcome.
Good day.
Bill, the Detroit bankruptcy is in full swing with major hearings in October. The question of whether the Motor City is eligible for Chapter 9 municipal bankruptcy is going to be front and center. It seems obvious that Detroit is financially as bankrupt as a city can be. What are the difficult legal issues lurking on the question of eligibility?
Oh, there's a humdinger. There really is, Lee. A question raised by some of the workers in Detroit. They are contending that Detroit should not be in bankruptcy on account of state law and the state constitution, which together protect workers' pensions. Also, they're raising issues about home rule, saying that the emergency manager should not have been able to put the city into bankruptcy, should have been done by elected representatives. At the end of the day, they may lose on that issue. However, the question is, who makes the decision? These workers are represented by some very smart lawyers who said that under the Supreme Court's authority in a case called Stern versus Marshall, these are issues that should be decided in a federal district court, not by bankruptcy court, because they turn on issues of state law and state constitutional law. And I tell you, Lee, this is not a frivolous issue. It may well be that the bankruptcy judge is simply bereft of power to make rulings on these issues. Were this case just a few hundred miles away in Illinois or Chicago in the Seventh Circuit, this would fall into a situation that where the Seventh Circuit recently ruled that the case would have to be taken automatically away from the bankruptcy court. At any rate, this is a really, really live issue which you bankruptcy nerds out there are going to enjoy following.
Yeah, it's certainly something we'll be paying attention to. Bill, let's talk new filings for a moment. It's often said that people with failing businesses just go away on vacation in August, and then when they get back in September, that's when they file the thing into the bankruptcy system. That phenomenon seems to have played out again this year. We had a quiet August, and then last week we had a big furniture maker file for bankruptcy, and we have another significant filing this week. This time it's the owner of Friend Finder Adult Websites. I guess that's Grindr for straight people. Can you fill us in on the details for this one?
Well, I guess, Lee, it's really pretty simple. That is, there is just so much sex on the internet that it's not profitable anymore. What a terrible turn of events. This is a considerable size company. Friend Finder is the name. Their premier website is called Adult Friend Finder. I'm sure that's all people are looking for is friends,
right,
somebody to chat with. In any event, it's a big operation. They have more than 8,000 websites, and they have, $550 million in 3 issues of notes. However, as is usual these days, Lee, I think this is going to be a pretty boring case. A deal has already been struck where the first lien lenders will be given brand new notes for the same amount without taking a haircut, and second lien debt about $330 million.
Not a small company.
No, not at all. We'll take all of the new stock. Unsecured creditors are going to be paid in full. Ergo, Lee, this is like a lot of bankruptcy these days. It just isn't going to employ very many bankruptcy lawyers.
And case of the week is American Airlines because there are 2 significant court decisions, one by a bankruptcy judge and the other in the Circuit Court of Appeals. Which of the 2 is more important for people looking at the bankruptcy matter?
You know, that's a really good question. Which is more important? And I'm not sure. I'll let our viewers decide for themselves. So let's start off, however, with the bankruptcy court. A decision by bankruptcy judge Sean Lane. He told American Airlines that they could and couldn't get away with a couple of issues in their reorganization plan. He said that it was acceptable to pay the counsel fees for individual members of the AMR Creditors Committee. On the other hand, he said it is verboten to pay a $20 million severance bonus to Tom Horton, the outgoing AMR CEO. Now, some people would have been of the view that the bankruptcy court excluded or precluded both of those payments. Bankruptcy Judge Lane agreed that it does preclude paying the severance bonus for the CEO. However, he saw basically a loophole where they could pay counsel fees for individual creditor committee members. This is good precedent for other people on paying creditor committee members. It is very bad precedent for Mr. Horton because Judge Lane in process said that the amount of the bonus, $20 million, was simply unreasonable. He left the door open for AMR's board after they come out of bankruptcy to give the man something or employ him somehow. But the problem is, if it's $20 million, you have a judge who already said the amount is unreasonable, given the sacrifices that the workers had to make in taking this puppy out of Chapter 11. So it very well may be that poor old Mr. Horton is out $20 million.
We end, as usual, with the advance sheets where we talk about important cases. This week, we go to the Ninth Circuit Court of Appeals in California. What did they decide that's so important?
Well, first off, let's keep in mind this is the Ninth Circuit. To the thinking of many people, whenever the Ninth Circuit speaks, that is an opinion to be taken with a larger grain of salt than you might from courts elsewhere in the country. This is, however, an extremely important issue about tax in bankruptcy, and for anybody out there in bankruptcy practice, you need to read the case. It's called Wilshire Courtyard versus California. Here is the deal. The bankruptcy judge, in confirming a Chapter 11 plan, described what a certain transaction was. He said that it was, if I recall correctly, a bona fide sale. The California taxing authorities took issue with that later and said, no, it's not. They recharacterized the transaction, and we're going to impose many millions of dollars in taxes on the principals in this company who are involved in the transaction. The lower court said there is no bankruptcy jurisdiction for the bankruptcy court to involve itself in this tax dispute. The Ninth Circuit said, yes, there certainly is. This is an issue that can be heard in the bankruptcy court. As background, most courts, including the Ninth Circuit, take the view that jurisdiction is more narrowly construed after a company emerges from Chapter 11. Acknowledging that that's the general law, the Ninth Circuit nonetheless said that this is close enough to integral parts of the Chapter 11 case that the bankruptcy court has every right to be able to pass on this issue governing tax treatment. This, folks, is really important for the following reason. It means that someone can engraft into a Chapter 11 confirmation order all of the facts necessary for a specified tax outcome. Because you can therefore bring the case, a tax dispute, back into bankruptcy court, it means it can be made extremely difficult, if not impossible, for state or federal taxing authorities to recharacterize what the bankruptcy judge said a transaction was in the first place. Ergo, this is a ruling from an appellate court that gives a great deal of power to people in structuring the tax outcome for a complicated Chapter 11 case.
Good stuff. Bill, thanks for that.
You're welcome.
That's Bloomberg News Bankruptcy columnist Bill Rochelle. If you'd like to learn more about the cases and issues we just ran through, be sure to go read his daily bankruptcy column. It's available on BloombergLaw.com, and it's also on the Bloomberg Terminal. You can see more of our videos on YouTube, and you can follow our updates on Twitter. I'm Lee Pacquiao. Thanks for watching.